And basically that would give us an idea as to what's the response to these recommendations that were made by the various stakeholders during the presentations to the committee. So Ms. Murray, CTD in Ministry of Science, Energy and Technology, I think will be leading us in this. So Ms. Murray, if you want to just give us a quick overview, and then you can start right away into the presentation of the matrix. Over to you, Ms. Murray.
Thank you. Thank you, Minister. Morning, members, morning, colleagues. As Minister Vaz indicated, we have been, with the support from the LRD, Legal Reform Department, and the Office of the Parliamentary Counsel, and of course the AGC, been reviewing the comments that would have been received by the committee in respect of the Cybercrimes Act. And before you today is a matrix that treats primarily with sections 2, comments received in respect to section 2 through to 8. Members will recall that at least 10 stakeholders would have submitted written submissions, and then of course orally would have made their presentations to the committee. And so I propose to share my screen. The document was shared yesterday with the committee members, but I'll share my screen and then I'll take us through each section that received a comment. I will, members, be calling on from time to time the Legal Reform Department to speak to matters that we would have asked them to opine on. And although in the matrix, I would revert to them to just walk us through their findings and their recommendations in respect to those sections, as well as colleagues from the ministry for support from time to time. So I'll share my screen now. And just to confirm that my screen is being seen and that you're hearing me clearly as well.
Yes, to both.
Thank you very much.
Loud and clear, loud and clear.
So the first matter that we're going to be looking at today is with respect to the definition of computer. We have 3 comments, but coming from one stakeholder, and that stakeholder was the Jamaica Bankers Association. They remind the committee that the definition of computer includes a reference to data storage device or electronic communication system, but they go on to make the point that data storage device is not, doesn't need to be connected to a network, nor does it need to be part of an electronic communication system. And so they were unclear whether the Cybercrimes Act is intended to cover only crimes covered over a network, whether that network is a public network or a private network, or is intended to cover crimes committed using an electronic device generally. So that's one comment that they had. And then the other comment was in respect of the definition of data storage device. They have recommended that the term data storage device be defined. And finally, they have sought clarification as to the crimes that are included under the Cybercrimes Act. So with respect to the findings, we note that section 2 of the Cybercrimes Act, that's the interpretation section, defines computer as meaning any device or group of interconnected or related devices, one or more of which performs an automatic processing of data. And of course, that computer includes any data storage facility. When we review the Cybercrime Convention, which from our consideration of the legislation was informed by that convention, though as members may know, we are not a party to the convention. It seems to us from our review of the 2015 Act and the previously repealed 2010 Act, that the Cybercrime Convention informed the drafting of our legislation. So when we review the Cybercrime Convention, we note that while there is no definition for the term computer, they have defined the word computer system. And computer system is the definition in the Cybercrime Convention for computer system is similar to the definition that we have in our legislation for computer. So they've defined a computer system as any device or a group of interconnected device. There is an explanatory report that comes along with the convention, and in that report, it is noted that a computer system is a device consisting of hardware and software developed for automatic processing of digital data, which can include input-output storage facilities and can be standalone or connected to a network. And then we also note the Cybercrime Convention Committee guidance in respect of the convention that says that a computer system could include our mobile phones, which have among their functions the capacity to produce, process, and transmit data. So based on our definition of computer, as well as our own research and of the research which reveals from the perspective of the Cybercrime Convention that computer system includes a device or a group of connected device in response to the JBA's question about whether or not the legislation applies to a standalone device. Our response is yes. The definition of computer speaks to any device or group of connected or related devices. And so it is our view that the legislation is sufficiently clear from the current definition of computer that the Act covers both a standalone device and a group or a group of connected devices. With respect to
Okay, could I just ask you a question there?
Sure.
I support your conclusion. Would, as we move to the Internet of Things and your fridge is connected to your phone and everything, it would cover, for example, a device like a fridge, if a fridge is connected, or your microwave, as we connect all of these devices?
I would defer to Lieutenant Colonel on this, but I would say yes, Minister. Sorry, my apologies, Member. I would say yes, because to the extent that it performs automatic processing and is connected to something else that is supporting that, then it would, in my view, fall within the definition of computer. But I would defer to Lieutenant Colonel as our technical or more technical person in the ministry in respect of this. I don't know if he has an intervention.
Good morning, Minister. Good morning, members. And the specific question that Member Robinson has asked, the answer is yes. The Internet of Things actually is now considered in like form to any computer system for both cybercrime legislations and cybersecurity legislations across the globe. And one of the reasons for that is as we connect things to the internet, particularly as we move towards smart homes, smart cities, we're seeing where the third-party components, which actually allow these devices or these equipment to be controlled electronically, are subject to and susceptible to the same sort of activities that cyber criminals perpetrate against computer systems as specifically defined in our legislation.
All right, thank you. Thank you.
Thank you. So I go to the second point from the Jamaica Bankers Association with respect to the definition of data storage device. And I'm just scrolling, forgive me. So we note that the Cybercrimes Act doesn't actually use the term data storage device, but rather data storage medium and data storage facility. So in the definition of computer, the legislation uses the word data storage facility, and then at sections 2, 5, 16, and 17, there are references to data storage medium. We note that the Cybercrimes Convention doesn't define data storage device. However, in our review of legislation from a number of jurisdictions, what we found was jurisdictions that defined computer data storage medium, data storage device, as the case might be. And countries are listed there: Australia, Barbados, Botswana, Kenya, South Africa. However, we also found countries where there was also no definition for computer data storage medium, data storage device, or any definition in relation to that. And we have a list of those countries here. And so our recommendation, and I'm scrolling back, apologies. So with respect to the inclusion of a definition for the term data storage device, as we could find, as we said, no evidence of jurisdiction that define the term. Well, we found evidence of jurisdictions that define the term in some other way, or they use a different permutation of the word of the term, but none that actually defined data storage device. And then, of course, we found jurisdictions that don't define any at all. So we are of the view that the Cybercrimes Act need not be amended to make provision for a definition for data storage device, as we believe the definition in the Act of computer data electronic communication system negates the need for an explicit definition of data storage device, as together these definitions inherently refer to electronic devices that store data. So that would be our recommendation in respect to that particular point about including a definition for data storage device. Again, bearing in mind, members, that I indicated that we actually don't use that term. And so if we were to define anything, we'd actually be defining data storage medium. I'm pausing because I'm not sure if members, I should, well, I'm going to assume that if I'm not interrupted, that members don't have a question. And then the final observation.
I think for that though, I'm still trying to digest it. And I'm looking back at some of the countries who would have utilized their definition, somewhat outdated also in terms of the dates of their legislation. So I'm still trying to digest whether or not the electronic device can be an all-encompassing definition, if that is what you're suggesting to us.
Well, if you look at the definition of computer now, for example, in our legislation, the definition includes data storage facility. And without more, if you apply this to the ordinary definition or the ordinary meanings to that word or that term, and how it is used in the context of the field, then we believe that the ordinary definition would work, and nothing more needs to be said, essentially. We really don't see a need to give a specific definition in respect of data storage medium.
And you're saying that because it says includes any data storage facility?
Correct. And we believe that the industry understands what a data storage facility means, and so therefore there would be no merit in adding a definition for data storage facility or data storage medium.
Fine, I take your recommendation.
Thank you, member. So, and then the final comment from them was clarification about, what crimes are included under the Cybercrimes Act. And here we just make the point that we believe that the Cybercrime Act is clear as to the crimes it covers. Those crimes are articulated at sections 3 to 9, whether it's illegal access or unauthorized access or unauthorized modification, computer-related fraud or forgery or malicious communication or obstruction. We think the legislation is sufficiently clear or very clear as to what it is that it covers. And that would just be the point that we would make there. So I will then move to comments received in respect of the definition of damage. And here I will I'm going to ask for support from the Legal Reform Department on this particular one, but I'll just take the members through the comments that have been received. And in respect of this, we have comments from the University of Technology, Jamaica, MOCA, as well as the private sector organization. And essentially, they have argued that they believe that the definition of damage needs to include causing mental or psychological injury or mental or distress. So causes or threatens physical injury, mental distress, or death to any person. And while the PSOJ and UTEC didn't give a reason for that recommendation, MOCA did. And MOCA essentially has argued that damage, the way we have defined damage in the Act, links it to the impairment of the computer or of a computer. And we have one particular offense at section 9, and that section 9 offense is the malicious communication offense, that it would be difficult to relate that definition to, because the injury or damage that could be caused by the committing of that offense is not one that would affect a computer, but in fact an individual. And so their recommendation, like the University of Technology and the private sector organization of Jamaica, is that the definition of damage be amended to include mental or psychological injury or mental distress. And I'm going to hand over now to LRD to take the members through their findings in respect of this and what their recommendation is. And then I'll come back. So I'll pause here.
The video is on. It's still blocked.
We're hearing you, LRD.
Okay. Okay.
Morning, members. I'm Andre Basco from the Legal Reform Department, and I have with me Erica Simon. We're having a bit of connectivity issues this morning, so if at some point we block out, we'd appreciate if you could just let us know where we left off when we were with you. So as CTB has correctly identified, the stakeholders indicated that there were issues in terms of a lack of acknowledgement of the potential for psychological injury as a form of damage. And additionally, the definition of damage was restricted to impairment of the computer integrity of the data. So what we found when we were conducting our research is that in other jurisdictions like the Bahamas and Trinidad, we have a similar definition for damage that does not include psychological injury. But there are other jurisdictions, and if you look at the matrix, you'll see that CTB identified the provision that we indicated from Kenya's cybercrime legislation, which includes an element of psychological injury, although it's limited to an interception offense.
think we have lost them.
I was wondering if it was me, Julian, but
Which,
While they come back on, and I don't know who best to direct this to, I support the inclusion of the psychological damage or the mental. The only question I would ask is, how would you quantify that, and who would be the competent authority to determine that? Because an individual could say, I have suffered this, but who would then be able to verify that this is actually so? Because it's not something which is easily quantifiable. So that would be my question in relation to that specific provision, while we await them to comment back on.
are you hearing us now?
Yes, I'm hearing you now. Yeah.
Yeah, hearing you loud and clear.
Okay, so we actually did some additional research on that, just to see how it operates in our jurisdiction. And in the sentencing guidelines that our courts have issued, we do recognize that the court has identified that harm does include both physical and psychological harm. What we have seen locally in how it operates is that sometimes an assessment of harm is done by way of a victim impact statement. In the Criminal Justice Administration Act, for example, the aspects that deal with plea negotiations, there is a reference to victim impact statements, which essentially would outline the effect that the offense would have had on the victim. For expert evidence, unless the court otherwise determines. What the court is doing is making a factual assessment of whether or not the person has suffered psychological injury. The second means by which the court can consider the injury is by way of the victim impact statement. And the third, of course, is if the court has an opportunity to assess the victim, either during the sentencing phase or prior to. So a lot of power is vested in the court to do that level of assessment. And we suspect that perhaps the court may also be guided by the civil approach in terms of how psychological injury has been treated.
Okay, thank you. You can go ahead. Yeah.
Well, in regard to that, what we had recommended to the Ministry of Science, Energy and Technology was that in addition to inserting psychological injury as an aspect of damage, that the limiting element of it being related to the impairment of a computer or data should be removed from the chapeau of the definition. So you would now have an expansive regime that treats with damage that's not contingent on an impairment of the computer or data.
Thank you, Mr. Basco. So members, that was the recommendation. So you'll see on screen the proposal from the LRD in respect of adding, and I'll just go straight down to G, adding psychological injury. The LRD would have indicated that their preference would be for psychological injury as opposed to the use of the term mental injury or mental distress. We, in reviewing further their recommendation, and we would support it as a ministry, we would propose to the committee some further amendments to the definition of damage to widen the category of information or data that can be impaired beyond that which is now included, which is a reference to medical examination, diagnosis, treatment, or care of one or more persons. We think that that specific reference is limiting, and we would say, or recommend rather, that we widen the category of information. And additionally, we propose that we make specific provision for the impairment of the computer itself. That is the integrity, confidentiality, or availability of any data or program held in the computer without the need to show any other type of loss. So I'll just take the members back to what the definition looks like now, and you see what the proposals essentially is. So if we look at the definition here, it says damage means any impairment to a computer or to the integrity or availability of that data that causes these things or modifies, causes economic loss, modifies or impairs or potentially modifies or impairs the medical examination, diagnosis, treatment, etc., causes or threatens death or physical injury, threatens public health or public safety, or causes or threatens physical damage to the computer. Mr. Basco would have indicated that the LRD's proposal is that we strike the words from the chapeau impairment to a computer. And we're proposing that that language be reinserted in the list in addition to the recommendation for inclusion of physical, I apologize, psychological injury. And so I'm scrolling down a little because I want the members to see effectively what if the recommendation is accepted, what the definition would now look like. So the definition of damage would therefore read damage for the purposes of section 3.3 and the rest of them here means economic loss, any impairment to a computer or to the integrity, confidentiality, or availability of any data or program held in a computer, physical injury or death to any person or the threat of physical injury or death to any such person, a threat to public health or safety, physical damage to a computer or the threat of physical damage to a computer or psychological injury. And I would just add one further thing. When we look at the scheme of the legislation and the references to damage, it's always in the context of whether or not the court is going to consider that because there is damage, then there should be what I would term it aggravated fines and or aggravated terms of imprisonment. So you'll notice in the legislation that it speaks about if damage is caused, then a fine of X or a term of imprisonment of Y. And so the assessment that Mr. Basco spoke to, based on the question that Member Robinson would have raised, then would be factored into all of that. And the damage.
Can I ask a question?
Sure.
Mr. Chairman. Okay. Morning, colleagues, everyone. So I like the idea of adding in the psychological injury as a factor. And Mr. Chairman, my camera isn't on because something is wrong with my Zoom this morning. I'm not getting the camera on. I note that in this committee, if I remember well, we have the president of the Jamaica Psychologists Association, Senator Longmore. And I don't know if she could give us some idea as to whether or not, in her opinion as a psychologist, she thinks that this is something that could actually stand up as we are intending it to do, just so that we have a little background information, just as we have a little support for which we're trying to do, because as a non-psychologist, I think it's a wonderful idea, and I do think we need to, this is us, giving credence to the fact that mental issues and psychological issues are important for consideration and the effects that can happen in people's lives because of psychological injuries. I don't know if Dr. Longmore is on the call. I didn't even scroll to see if she is, but it would be good if we could get some idea from, a psychologist to see, or a psychiatrist to see how this would stand.
I am here, Chair. I was waiting until the other comments were made. I see Miss Judith Grant's hand is also up. Good morning, all.
Yes, thank you, Member Longmore. I just wanted to make the
Not hearing you.
Injury. And I was wondering,
Judith, could you repeat yourself? We
intending
didn't
for
hear
that
you.
Judith, you have to repeat yourself. You're cutting out. Start. Find a better location.
All right, thank you. I've turned off the camera. Maybe that might improve the audio.
Yes, absolutely. Yeah.
Yes. Yes, I was indicating that just qualifying that the proposed revision would be subject to some drafting refinement, and I'm querying what is intended to be covered by the term psychological injury, because to me that seems a bit wide in terms of what that could cover.
Chairman, if I may.
Go ahead, Member Langwa.
Thank you. And good morning again. Belated Happy New Year to all. Okay, so thank you, Senator Campbell Rodriguez. I was, as I said, waiting until members made their comments before I came in. I'm very glad to see this recommendation. It is very pertinent, and the fact that there is increase in awareness of the impact on our minds. Let me start with our minds. Senator Campbell Rodriguez, it's the Psychiatric Association, very different from the Psychological Association. And this brings me to the recommendation that I was going to make, which I would actually suggest that we use mental injury as opposed to psychological injury. It is one of the shortcomings that we recognize as we seek to reform things like the Mental Health Act, et cetera, because with growing awareness as to the distinction of the use of terminology, the word mental includes psychiatric as well as psychological. Psychological injury, both can be interchanged, yes, but mental is more covering all aspects of emotional, behavioral, as well as the psychological impact. Necessarily behavioral might not be covered by psychological, especially if it has a psychiatric component to it, and it is a very technical difference. But the impact that can be had might not just be restricted to a psychological damage. It can also include a psychiatric component, which could arguably not be included by that definition. So my suggestion would actually be to use mental injury, which would be more broad covering. And Member Robinson's concern in terms of validating such as I think it was Mr. Basco indicated, is that we would use the usual mechanisms of validating mental injury, which is quite established. Thank you, Chair.
Ms. Murray, back to you.
Sure. Thank you. Thank you, Minister. Chairman, I'm not, based on the comments from the members and the question from CPC, I wondered if LRD would want to add something here. I know they did some research and would have found a particular case in our own Jamaican courts that recognize psychological injury. So I'm not sure if LRD AGC has a response or in respect to the recommendation just now as to what, which term to use, whether mental injury or psychological injury, and then if so, how would we define that to CPC's question? If, Chairman, there isn't an immediate response, then maybe we can come back to this in terms of what that would look like. You can come back to the committee on that. And we'll just proceed.
No one from the audience here? No?
Chairman, I agree. If we can resolve this, I am seeing the challenges in trying to bring into scope the psychological injury or impact. But if we can't resolve it now, maybe we need to just red flag it and come back to it. Because I believe it requires some further analysis. I'm looking at the submissions. I saw the submissions from UTEC in terms of what the cyberbullying may cause. I'm looking at what, what's it? Was it MOCA? No. There's another grouping that, the Major Organized Crime Anti-Corruption Agency, where they would have suggested the use of a computer for malicious communication. It becomes apparent that the definition as framed is incompatible with that offense. I think we see where the use of damage in terms of the computer lies, but how do we incorporate the psychological impact? I know for a fact, bullying can create some psychological impact to users or those who would have been the recipients of it. It's just where we tie it in, Chair, and I believe we should come back to it at some other time and allow for further review to be done.
All right, all agreed? Proceed, Ms. Murray.
Agreed.
Thank you, Chairman. So we'll move on then to the next comment, which was in relation to the definition of function. And here I'll just define what function, direct the members to what function means or how it has been defined in the legislation, and then I'll share the comment from the University of the West Indies. So function is defined as including logic, control, arithmetic, deletion, storage, retrieval, and communication from or within a computer. And the UE has pointed out that the word deletion is used here, and because deletion is there, then consideration should be given to adding the word addition or the words addition and modification to the definition. We did research this matter, and we found at least 9 jurisdictions. We looked at 9 jurisdictions rather, and we found 5 of them that do not define the word function at all, even though the word function is used in their legislation. And then we also found countries where the word function is defined, but it is defined in exactly the same way that Jamaica has defined the word function. So we have found no evidence of the word function being defined to specifically reference the words addition and modification. But in our minds, this doesn't mean that these words are not included in the definition. We know that the definition utilizes the word includes, which suggests that the function is not limited to the term specifically referenced in the definition, and one could then infer that by the word includes that modification and addition is also included. So in light of that, as well as the fact that we really couldn't find any jurisdictions that have defined the word to include addition and modification, we're not suggesting that the definition be disturbed as presently worded. Members, all right, so if there are no comments, then I'll just proceed to the next point. The next comment, again from UE, was in relation to the definition of the word key. it's UE and UTEC, and what they both identified was essentially a typographical error in the definition of key. There is a reference to the word date where it actually should be data. So we take that point that there needs to be an amendment to replace the word date with data. Then move to comments that we've received in respect of the word access, and return to the private sector organization of Jamaica. Their concern is that there is a danger that innocent actors who find a vulnerability in interacting with a computer may not have willfully done anything, but would be captured by the act. We know that the term access is defined to mean, well, it says that for the purposes of this act, a person who accesses, modifies, or uses any program or data held in a computer or causes a computer to perform an action does so without authorization. But access is also specifically defined as if the person causes a computer to perform any function that alters or erases the program, copies or moves it, causes the program to be executed, and so on. And I believe the challenge that the private sector organization is having is that there are instances, or they're suggesting that there are instances when an innocent actor may find a vulnerability, and that vulnerability is found unwittingly. We note that, and we looked at the explanatory report in respect of the Cybercrime Convention, and we note that the conduct which is referenced in the convention must be committed without authorization, or they use the word without right, we use unauthorized, which means that there is no criminalization of access that is authorized by the owner, one, or the other holder of, or the right holder, and there is no criminalization for access to a computer system that permits free and open access, so to the public. So where a system is public facing and the public uses that, then there is access by right, because that is how the system was set up in and of itself. We also note, however, that
Joaquin, can you just pause, just so
Sure.
I'm clear? So if I'm an ethical hacker and I make a determination that as part of my responsibility, I'm going to check on these systems that are owned by the government, and I go in there, identify a vulnerability, which I openly report and bring to the attention of the government, I would be guilty of breaching the Cybercrimes Act because I'm doing it without authorization.
yes.
Okay.
So our legislation, as it is framed now, doesn't permit ethical hacking, essentially.
And no, sorry, go ahead.
Right. So any access must be that which is authorized, and anything beyond that is considered, can be considered a commission. Well, would fall possibly within the commission of one of the offenses under the legislation.
And we're sure, before you come in, Kevin,
Yeah.
we're sure we want to do that. I know it's a very thin line, and I know it's difficult to determine whether people are genuinely interested in assisting and solving problems, but we also know there are bodies and groups of individuals out there who go around and check whether sites are secure, and when they do find vulnerabilities, they bring it to your attention so that you can take action. I'm just not sure if we want to criminalize that kind of conduct, particularly where individuals are seeking to help, which is in essence what this does.
I agree with you, Julian. Somebody carrying out research, come up against issues in an ethical way, as has indicated we don't recognize ethical hackers, but you have persons with the skill set that are working in an organization, carrying out their duties, and would have come up across these vulnerable situations by conducting real research. And they would be viewed as being committing a criminal act. Yes, it's a very thin line, but it's a line that we need to explore in order to protect these individuals who would have been, conducting work in a real way under research. So I believe it's something that we seriously need to look at.
I mean, this issue came up in the jam COVID scenario last year. We know about that person, the journalist who was doing his own research, and he would be guilty of a Cybercrimes Act. Now, I don't think the authorities pursued it, but I don't know if you want to discourage persons in that regard from doing that kind of work, which is done, frankly, all over the world. I'm not sure what other legislations provide for, but I don't think as a country, with our very limited resources in this area, with us moving more to online with NIDS, etc., we will never ever have the internal resources to properly police all our networks. And so the extent to which you have individuals who want to assist, I don't think we should criminalize that kind of activity.
And this is where it would have been
you finish.
It would have been saying unwittingly, unknowingly, and without intent. So they never went there to create any malicious intent. But in carrying out their work, they would have come up across the challenges and report it to whether the organization to which they are working with or the authorities, that they would have identified these challenges. It ought not to be treated, Chair, as them committing an offense.
I see Mr. Sterling,
Yes, Minister. If I'll just defer to Lieutenant Colonel on this one.
Thank you, Chair. And in responding to the specific concerns raised, we have to take a few things into consideration. We really ought to separate the unwitting discovery of vulnerabilities into two basic categories. The first being someone who makes the discovery as part and parcel of their job function, whether that is as an employee or a third-party contractor. And secondly, as someone who just simply, without any knowledge or authority from the owner, tries to probe and break into internet-facing resources. In the first case, the group of persons so operating would have been indemnified by the terms of their employment and/or contract, and as such, their discovery of vulnerabilities and/or breaches that are reported to the owners of these resources would not be covered or would not seem to attract a penalty under the Cybercrimes Act of 2015. If, however, the person so operating is a third-party contractor with specific scope and guidelines for operating, and in so operating discovers a vulnerability and fails to mention it to the person who contracted them, but seeks to make it public, they are actually creating a different sort of challenge for the owner of the resource, and they would have gone outside the scope of the work they were contracted to do. And this, I believe, ought to constitute a crime. The second group of persons being from script kiddies to actual activists who just simply are probing internet-facing resources. Given our maturity from a cyber resilience and cyber hygiene standpoint, what it does when these persons do this is that it also puts the owners of those resources, particularly small businesses and individuals, in a difficult position if they're unable to remediate the vulnerabilities that have been identified and or fix the breaches that have been discovered. Now, if these persons are intending to probe an internet-facing resource, there is provision under the Act for these persons to firstly make contact with the owners of the resource to say, look, we would like to, as part of a research that we're doing, do this to your internet-facing resource. If that owner is amenable, then the authority question is answered based on the acknowledgement and approval that would have been given for this to happen. Where it doesn't happen in that way, even if the person or persons are legitimately carrying out security research against resources, the fact that they would not have approached and gotten approval from the owner of the resource means that they would be guilty of an offense under our legislation. Now, Member Robinson mentioned the jam COVID situation. And if we look at the chronology of it, the person who discovered the security lapses sought to, on their account, communicate this. When nothing was done, i.e. the lapses were not remediated, they took it public, and we saw the result of that in terms of the embarrassment to the owners of the resource, and also the fact that it allowed other persons who would have not necessarily been interested in the resource to try to do the same thing or to do worse, where in a follow-up action, a so-called security researcher actually exploited the vulnerabilities that were documented in Zach Whitaker's article and exfiltrated data from the site. Now, when we think about how this happened with Jam COVID, if we take it to the owner of a resource that is less capable, less able to remediate the situation, then we're putting those persons and their resources at risk, even though it is at risk, if we do not do it in a way that they are aware that the probes are being done and they've given approval for them to be done.
Godfrey, I hear you, but I must tell you, if you, and you know this more than me, if you look around the world in terms of how these guys operate, particularly the activists, I mean, nobody is going to come to you to seek permission before they probe, right? They generally probe. In many cases, they will indicate that they have identified a vulnerability. Where they go public is generally when they feel that either the organization has not acknowledged or has ignored or has taken no steps to remedy it. And in many cases, it tends to be public networks. You know, when people are going for private networks, there's generally a profit motive there. And, you know, that would form more into the realm of you have ransomware, you have that kind of thing. And that's clearly criminal activity. But the activists tend to be focused more on public infrastructure and public networks. So I hear what you said, but I still can't agree that that kind of activity, even where it is not authorized and permission isn't sought, because these guys aren't seeking permission. There are guys who are there primarily to demonstrate their own expertise. There's a bit of ego in it because they want to show that they can get into particular websites, so they do it, and they do it for fun. They're not the criminals, and I don't think we should criminalize it. And I believe while it can be very embarrassing to our government, there is benefit in having persons who bring something to your attention and give you an opportunity to fix it, which was my understanding of Jam COVID, but I didn't know the details other than what I saw in the press and what that journalist reported.
If I may just have a follow-up comment to that, Chair. The fact that these activists are out there and by and large, they seek to do good. I agree with you, Member Robinson. But we have to take into consideration our own personal situation here. And as we mature our cyber resilience and our cybersecurity, our ability to respond to cybersecurity threats improve, we can iteratively remove some of the requirements. But given where we are now, and we will revisit this again when we look at section 241, I believe. But when we look at it, the nature of how our internet-facing resources are sometimes secured, if we do not maintain the sort of deterrent effect of criminalizing this activity, I fear that what we will do is essentially declare open season on these resources. And while there will be activists out there who will act in the public interest for the greater good, there will be some who will be seeking to do it simply because they think they can, or to further other intent, oftentimes with a malicious component. So all I urge is that for now, we do not change how our legislation is structured by creating or specifically not criminalizing such actions, because there is provision in the legislation for persons who are legitimately conducting research or doing work, as opposed to those persons who may just be out for a stroll on their cyber walkway on a Sunday afternoon and trying to break into your system.
I just remember Bunting and Member Campbell Rodriguez in that order.
Thank you, Mr. Chairman. My point is that I believe, or the point I think this committee should weigh, is what is in the public's interest. Clearly, as the legislation is written now, it would have a chilling effect on the penetration testers who might be doing it in an ethical way. Knowing the bureaucracy of government, nobody is going to get any permission. By the time they put them through 1,000 hoops, they will either continue along their way or just do it anyway. But to me, if you create a regime which says, for example, if you discover these vulnerabilities, you report them to the relevant authority, either the entity that has that internet-facing asset or some central governmental cybersecurity authority, and you allow a period of time, say 30 days, for remediation or mitigation of whatever that vulnerability is before they can share with anyone, then I think that would achieve the balance between the what is a potential vulnerability if it is shared widely before giving the entity a chance to remediate or mitigate, or just leaving that vulnerability out there for a malign actor to discover eventually and wreak much more damage than would be done by the ethical hacker or pen tester.
Colonel, you want to respond to that?
Certainly, Chair. Thank you, Member Bunting, for that. And one of the things we have to bear in mind is that as we seek to mature our cyber resilience, the development operations, the security operations that go into putting resources out there, we really need to focus more on those as part of the root causes of why we have vulnerable internet-facing resources. And I take your point, sir, but that would have really been something that I hinted to when I spoke to the ability to do things within scope of speaking with persons and getting approval. And yes, some of the bureaucracy would be there, but that same bureaucracy would sometimes prevent the remediation within that time frame, as happened with Jam COVID. And then we ended up with what they reported it. And so, like you said, sir, it's really that balance that we need to strike. And I believe that for now, as we move full speed ahead to build our maturity within cyberspace, we really need the protection of the law for these, particularly medium and small enterprises and their internet-facing resources, before we actually start to open it up to for persons to be able to do this without any thought of repercussions.
Mr. Chairman, can I go ahead? Mr. Sterling, I must say that I support what has been said by Senators Gale and Bunting and by MP Robinson. Even the most basic cybersecurity courses at, internationally, because we don't really have cybersecurity courses here in Jamaica. One of the things they talk about is leaving room for white hat operations. And much has been said already about the Jam COVID incidents. I won't speak much to it, but I think it would be somewhat of a almost backward step to not allow for these kinds of interventions, because that's what cybersecurity is. Our government will never have enough resources in the short term. When you're looking into the future to 5 years, 10 years, to cover all our bases. And as such, we need to rely to some extent on white hat activities in order to protect our systems. So I really do not support the idea of us criminalizing this activity, because the benefits from it, I think, outweigh the negatives. Maybe what can be done is some research can be done by the support team to look at what happens in other jurisdictions, because our systems have to be protected. And I don't think we either have enough personnel in Jamaica who are cybersecurity experts to protect the systems, plus we don't have the resources to put everything in place. And as such, there has to be room for the white hat hackers to help us with these systems. So I would suggest that further research be done before we sign off on this issue.
All right, members, can we agree on that? We have, I see Mr. Basco and I see Mr. Sterling again. Hands up. Mr. Basco, you want to go ahead?
Thanks, Chair. If you don't mind, Chairman, I think when we turn on the video, the bandwidth is affected. But we just also wanted to indicate to the committee that this discussion is also bigger than cybercrimes. It may also have implications for the Data Protection Act, and that the relationship under the Data Protection Act between data controllers and processors is contractual. So it's also possible that if a decision is favorable to ethical hacking in this context, the Data Protection Act would also need to be examined.
I think it was announced recently that the Data Protection Act will be reviewed shortly, so I think the timing would be good.
If I may, Chair, the points raised by Member Campbell Rodriguez, I note and I accept. However, we ought not to conflate the role of a white hat hacker with the role of A, security researchers, and B, activists. The white hat or the blue teamer in cybersecurity really operates within the provisions of non-disclosure agreements, of existing legislations, of specified intent of resource owners. And not only by removing the criminal nature of what we're trying to prevent, are we saying it's okay, but in substantive law, it really would be tantamount to legitimizing illegal access to private property. And whilst in cyberspace, it is a little different. When we look, for example, at what Mr. Basco said about the Data Protection Act, there is a clause in there that speaks to for the, or in the public's interest. And that sort of catch-all prevents the criminalization of certain activities which may occur, but because it was done in the interest of the public, while it is dealt with, it is not a criminal offense. Within the Cybercrimes Act, however, the Act does not criminalize white hat hacking, nor does it criminalize security research done within a structured framework with the necessary approvals. And notwithstanding some of the perceived and actual bureaucracies and red tape that we might encounter. For example, if a university is delivering a course that has a security research component, there ought to be, based on the deterrent effect of the Act, that responsibility placed on the institution to say to the student or students, before you conduct this research, you must get approval. As it stands now, that approval is not something that is required for the completion of the research or the submission of the coursework. And what it would do in essence is to remove that requirement to do the security research on someone's internet-facing resource, whether it is for government, NGO, or private body, corporate, or citizen, and just allow somebody to do it. Now, when it does happen, as it will, and there is no prior approval sought, no scope within which these persons were acting, on a case-by-case merit, it can be dealt with. But to take it out of the Act at this time, given where we are in our maturity, and taking into account all the comments made about resources and the international practice, because we did do the research. And when we get down to section 241, a lot more will come out of it. But at this juncture, the recommendation based on our research and our actual interaction within cyberspace and dealing with cybersecurity in Jamaica, the recommendation would be to keep the provisions within the legislation as they are.
The final comment I'd make on this, and I still support the desire to have a review, is that really when I look at what the danger is, particularly to the public, and I was in that chair when we had a number of these incidents, is really just a bruised ego or an embarrassment to the government, particularly when it's public infrastructure. That's the main danger. The ones who want to create criminal intent will just go ahead and do it. But generally, when persons bring things to your attention, if you criminalize it I think you're denying yourself an opportunity to have the best expertise that exists. And the only harm to government is the embarrassment that somebody found out something before you did.
I concur with you, Member Robinson, on that point.
Chairman, if I might, in response, well, not really a response, but based on the recommendation that was made by Member Campbell Rodriguez about taking this matter, I suppose, putting this matter back on the drawing board. I hear, I think certainly what I've heard from the members is a focus on public sector. And to the point that Lieutenant Sterling made about this being essentially private property, and I'm using the term very loosely, that we would be legitimizing persons to really go into people's space and do as they feel without the person's permission. We can liken that, and the examples were raised in the context of the submissions last year, that you're really allowing persons to just enter into people's private property and do as they feel without the owner's permission. And I think we have to be very mindful of that. I know the comments have been contextualized in the context of the public sector and the fact that it's just an embarrassment for the public sector. But what members of the consideration with respect to private players and how it is that we would be legitimizing white hackers to go into their private space, even though some of these systems are public facing, and do as they feel there. And I think we have to be mindful of that. We will take this off air. We certainly didn't see too many jurisdictions that have allowed for anything like that. We want to remind members that when we started the conversation around the act, one of the very first meetings I recall, Member Campbell Rodriguez asking us to look out, bug bounty and so on. And we would have articulated that there's a framework within which these things can happen. And we have to be extremely careful that we don't open
Jamaica, home of the resilient, passionate and hard-working. A people and a nation who have achieved and defied all odds, working to keep their economy growing, their country thriving, from investments made in innovative opportunities and exports demanded globally. We have a vision, now within our grasp, where Jamaica becomes the place of choice to live, work, raise families, and do business. We will not let go of this vision. We will grow. We will overcome these challenging times and look to the future with hope and positivity. These are special times. The world as we know it has changed, but home will always be in our hearts. And in Jamaica, you can always find a home. Think you know Jamaica? Look again. You will be surprised.
And if you look at the scheme of our legislation and the offenses as articulated, they all require the person to do something knowingly or with intent. And so a reckless, negligent access or modification or so on wouldn't fall within the scheme of our legislation for consideration for criminalization, that a criminal act would have been committed. But based on where we are in the conversation, I think what we've been directed to do is to look at this matter again. The private sector organization went on to recommend that the legislation be amended to include the words willfully and knowingly initiates. But we believe because the legislation uses the word intent or knowing, then that is already covered in the respective offenses. We remind members that, or we would want to remind when they're reviewing this piece of legislation, they have to review the definitions in the context of how they are used. They can't just read the definitions in isolation of the actual sections. And as I indicated before, there is an actus reus mens rea element to all the legislation. My apologies, all the offenses in the legislation, and that particular mens rea, which is the mental element that is required, tends to be and is almost always worded as knowingly or knowing or intent, or with intention to, or with intent. So we wouldn't support the recommendation from the PSOJ that the definition of access be amended to include the words any function that willfully and knowingly initiates, as we believe that the mens rea of intent is already or intention or intentionality is already addressed in each offense as articulated currently in the legislation. So we had another comment from the UTEC in respect of the definition of access. Their concern here was that this section 2A provides that a person obtains access if he alters or erases the program or data. Alters or erases the program or data may relate to information that already exists. And it is proposed, they say that a person could gain access to a computer and cause it to create. And so their recommendation was that the section 22A be amended to include the word create. We noticed from our review that there were no national statutes, certainly from the ones that we looked at, which identified access as including the word, or, well, let me step back, which includes in the definition of access the word create. Our recommendation, therefore, to the committee is that we see no need to add the word create. We note that in the context of cyber or information security, one cannot really create anything. One simply adds to existing data sets. Certainly when you access, or you're adding to, or to an existing data set or framework. And so consequently, the word create is usually only the addition of a new instance of something to an existing data set or an existing framework. And that, we think, falls within the context of modification or alteration, which is already present in the definition. So in light of that, the MSET is of the view that the word alter, which is currently used in the definition of access, sufficiently covers the concept of creation or modification. And as we said, we really could find no national statute that included in the definition of access the words create. And so with that, for those reasons, we are proposing that there be no amendment to include the reference to create, the word create or creating. The next comment was from UTEC in relation to section 22B. The recommendation here is that we define the word storage. Members will recall early on that we spoke about, there was a recommendation that we define the word data storage device. I had pointed out that there is no reference to a data storage device in the legislation, but what is used is data storage facility and or data storage medium. The recommendation from the UTEC is that we define the word storage, and in a similar way, we don't think that there needs to be a definition of the word storage. We want to, so we take the time in the middle, in the third column to indicate that storage is used in the context of other terms. So data storage facility, it's used in the definition of computer service, and it's used in the definition of function. It's not really, it's never used on its own without another word. And so in section 2.2, for example, it said it's used as storage medium and so on, or data storage medium. So we don't think, and this is our recommendation, that storage, well, we've seen no legislation that defines storage. In the same way we saw very few that defined data storage device or data storage medium or so on. And so we would recommend that there be no amendment of the legislation to include a definition for storage. We note that where words are not defined in legislation, the literal rule of statutory interpretation is generally first applied, and then that word would be given its ordinary meaning. And so in that case, we would support a definition for, well, the inclusion of a definition for the word storage. We're coming to section 2.4b, and it's a similar conversation as we've had before in respect of unauthorized and access, or unauthorized access or unauthorized modification or unauthorized use that we would have had before. The concern being here that the definition, well, according to you, is that the definition should more accurately represent access to resources in the digital world, if needed. They point out that the definition of unauthorized requires the explicit grant of consent to access to a computer or computer system. And they note that, you know, an individual may access a resource regardless of whether or not measures were implemented by the resource owner to regulate its use. And they further state, I'll just scroll to where I'm at, and they further state that there are a myriad of examples of people who have unintentionally accessed a resource that they have absolutely no interest in because the resource owner has not secured him or herself or itself. They contend that the local environment that we should really be trying to engender or to create is one where individuals may find flaws or vulnerabilities, including poorly defined privileged and access controls, and report them without fear of possible prosecution. And in that regard, they are recommending that the definition of what an unauthorized access is or would be amended to include a stipulation that such access occurs when an individual attempts, successfully or not, to circumvent the included digital implemented privilege assignment and access controls of a resource. So that is essentially their comment, still tied back to the conversation we had earlier about what would be allowable. We point out here, members, that the scheme of our legislation informed by the convention is that access must be without with consent or with authorization. So there's in our minds, there can be no criminalization where the right holder permits free and open access by the public, as this access is deemed to be with right. We reiterate the points that we had made before, that the offenses in the Cybercrime Act require an actus reus and a mens rea for the commission of an offense, and where therefore a person unintentionally accesses a resource, the requisite mens rea of intent, that is the deliberate taking of a course of conduct to bring about a result, which in fact occurs, would be absent. There would be no intention. And so the person who unwittingly, unknowingly, unintentionally does something, it would, in our minds, it would be difficult for charges to be pressed against that person, and successfully proved if the intention is absent. So that's essentially, so we don't support Yu's recommendation that the definition of unauthorized access be amended to include a stipulation that such access occurs when an individual attempts, successfully or not, to circumvent the included digital implemented privilege assignments or access controls. With respect to section 24B, we have a comment from Simtai, which is essentially a clarification that we think they were seeking. That clarification being whether the act punishes persons who, by virtue of doing their assigned or contractual duties or using the system as intended, causes an issue due to poor system construct. And again, it's the same point that we are making, that where you are permitted to use, where you are authorized to use, whether because you're an employee, a contracted third party, a contracted third party, where you're using or you're authorized to use a system and you use a system, but you happen upon or issues occur because of your use, and that's because the resource owner failed to implement the necessary or take the necessary steps to protect and to ensure or deny access or implement controls, then that could be no fault of the individual who has been permitted to use. So in our minds, the legislation would not criminalize criminalize any action that is either reckless, negligent, a mere accident on the part of the individual who has been authorized to use or would have been given permission to access that particular system. So where that person, as I said, is seeking, the act doesn't seek to punish a person who, by virtue of doing their assigned or contractual duties, or use a system in its intended format, assumedly, of course, with consent, causes an issue due to poor system construct. And members, we would have ventilated this particular concern from the PSOJ about the framework, the need for a framework to recognize ethical hackers in the legislation. And I believe Lieutenant Colonel would have articulated the position here in respect of why at this time it would not be something that we would support, but taking into consideration the comments from members that we take this matter back to the drawing board and then revert to the committee. We wouldn't go into this because we've ventilated that issue already. So I'm moving now, members, from section 2. So we'll have completed all the questions, comments, recommendations in respect of section 2. I'll pause for a few and just to allow members, if there are any additional questions or comment before we turn now to the substantive offenses, starting with section 3. All right, so the comment in respect of section 3, which treats with unauthorized access to computer or program or data, we have comments here from the Private Sector Organization of Jamaica and the Financial Services Commission. And with respect to the PSOJ, they are recommending that we insert the words as defined in section 2, subsection 2, that is a definition of access, be inserted in this definition, or this offense rather, so that it would read a person who knowingly obtains for himself or another person any unauthorized access as defined in section 2, subsection 2, to any program or data held in a computer commits an offense. I'll treat with this one now. The issue in our minds that has been raised by the PSOJ appears to be a drafting one. We know that interpretation section, we've gone through that already, of the Act presupposes that the words, when used throughout the legislation, are to be construed as defined in the interpretation section. Therefore, we don't see a need for any specific reference to the interpretation section each time a word is used, and therefore we do not recommend that section 3(1) be amended as proposed by the PSOJ. With respect to the Financial Services Commission, they have recommended that the offense be modified, essentially to introduce the words or causes to be obtained. So a person who knowingly obtains or causes to be obtained for himself or another person any unauthorized access to any program or data held in a computer commits an offense. Here, we'll just pause. I'll pause here just to indicate that, and I'm scrolling down to the particular section, that there is a section 12 of the Act that provides that a person who intentionally incites, attempts, aids, or abets the commission of any offense under any of sections 3 to 10, or conspires with another person to commit the substantive offense, commits an offense, and shall be liable to the same penalty as applies to the substantive offense, and to be proceeded against and punished accordingly. Sorry, just scrolling back. So with respect to the FSC's recommendation that the words or causes to be obtained be inserted, we believe that section 12 of the Act already treats with the matter of inciting and conspiring with another person to commit an offense under the Act, and therefore we see no need to amend section 3(1) to include those specific words. I'll turn now to the JBA. So the JBA notes that the offense is only committed if the person knowingly obtains unauthorized access to a computer, and it is suggesting that the offense should also include where a person's actions are reckless. That is to say, where a person ought to have foreseen or ought to know that their actions would result in unauthorized access. So they're recommending that either a catch-all new section or a subsection be included that indicates that this crime can be committed recklessly. In our research, what we found, and we looked at a particular report or study done by the United Nations Office on Drugs and Crime, and they note that the act of accessing a computer system without proper authorization has existed since the early days of the development of information technology. What we note is that like Article 2 of the Cybercrime Convention, our legislation requires that the act of access, unauthorized access, be done with intention. So Article 2 of the Convention, which is similar to or Section 3 or premised on it, provides that the parties to the convention shall adopt such legislative and other measures as may be necessary to establish as criminal offenses under its domestic law when committed intentionally. So as we looked at other pieces of legislation and or multilateral instruments, what we recognize is that the African Union Convention on Cybersecurity and Personal Data Protection and the Economic Community of West African States Directive on Fighting Cybercrimes within the ECOWAS requires the mens rea to be fraudulent. Or analysis of national legislation shows that the state of mind used for illegal or unauthorized access are intentionally, knowingly, willfully, and fraudulently. We could only, the UNODC study revealed only 2 countries, one situated in the Caribbean, and in our further research, we realized that this is Barbados, that allow for illegal access to be committed recklessly. And so based on the fact that our legislation in our minds would have been premised on the convention, which calls for this particular offense to be done with the mens rea of intention, or some similar permutation of that. And the fact that we couldn't really find any jurisdiction, save except Barbados and one other, that allowed for this particular offense to be done or to be committed recklessly, we would recommend to the committee that the offense not be amended to include recklessness. That would be actually creating a situation where reckless acts would be subject to disproportionate criminal sanctions. So our recommendation simply is that we should keep the mens rea where it is, that is the requirement for intentionality, and not introduce a situation where a person could recklessly access and be found to be criminal.
Before we move on from this point, Ms. Murray, so we're saying we're not accepting this recommendation based on the fact that only 2 other jurisdictions can be found as having it. For me, that one doesn't hold enough water because we are Jamaica and we have no problem as Jamaicans doing things differently from other persons as long as it's allowed legally. I'm not convinced from what has been said here today and from my reading of this recommendation that we should just not accept it. There are other things in the criminal, there are other things that are considered criminal due to recklessness. And cybersecurity and cybercrimes have become so heinous and have such a great impact that I would prefer if we explore this a little bit more before we just say no because no other jurisdictions have it. I'm not sure if you can provide some other reasons other than what you've already stated as to why we should not look at recklessness as a factor. Because some of the cybercrimes that exist can take down a company, can shut down a country, and recklessness should be considered as a factor because that forces persons then to be more careful with their actions. And so I would love us to hear a bit more, if my colleagues will allow and if Mr. Chairman will allow, just some more reasons when you counter it with the potential damage that can be caused from some of these actions.
So member, if we consider the conversation that we've been having to date, and some of the points that Lieutenant Colonel Sterling would have made in respect of our own maturity, cyber security, in cybersecurity, and even our cybersecurity hygiene, the lack of general knowledge of our people in when they interface with the technology, then what we would be doing, should we accept the recommendation, is that we would be saying that any Jamaican who goes onto a system or interfaces with a internet-facing system, and for whatever reason in interfacing with that system, either click on something that, and that thing could be anything, then that person could potentially their act could potentially be considered criminal, because the argument now would be that that person recklessly did what they did. So while we appreciate that there are instances where persons are careless as to how they interface, we had to bear, well, certainly when we considered it as a technical team, we had to bear in mind that based on where our we aren't a knowledge-based society. We haven't gotten there yet. There's still a vast number of our citizens who are not IT savvy, and in interfacing with these systems, if there are possibilities that things will be done, and there is really no intention to do what was done, and if we leave negligence and or recklessly as proposed here, we run the risk of criminalizing disproportionately those types of action, when what we should be focused on is really those persons who set out to knowingly, intentionally, willfully commit an act.
I think that's a subjective thought process. That's rather subjective as to we're thinking that people don't, you're thinking that people don't know, and as such we shouldn't we should allow recklessness because people don't know enough about computers. We passed a sexual harassment act recently. Most people don't know what is in the act. It directly affects our cultural behavior, the way people normally operate. But we had to pass the act because it is in the best interest of the population. So sometimes we do things because it's in the best interest, and not just maybe what we should be focusing on is helping to bring people up to the fore with this, rather than saying it's okay to be reckless, you will not be penalized in any way. I'm just not comfortable with this any at all. I've not heard enough arguments to support the idea that recklessness should not be considered. I personally don't know how I feel about recklessness and its consideration in this instance, but I'm not hearing enough to convince me as yes, it's all very subjective what you're saying, the thoughts of the persons from the ministry versus what actually exists out there.
So I'll defer to Lieutenant Colonel on this. I mean, he Lieutenant is the head of the CERT, and he would, I think, have an appreciation of some of the issues that have been encountered, because whether employees and or individuals, private individuals, by their action unknowingly cause certain actions. So I'll just hand over to Lieutenant Colonel here and for his intervention.
Through you, Chair, thank you, Ms. Murray. The consideration of recklessness when we examine cybersecurity speaks to really the schedule of punishment or fines, and the fact that even though you may have committed the same offense against different systems, if your actions are deemed reckless, then you would be liable for a higher fine or a more severe punishment. In the examination of a number of jurisdictions and their legislations, in the knowledge base that exists within the body, within the professional body for cybersecurity, reckless acts as far as cyber crimes are usually committed against what are termed protected systems. The Jamaican legislation does have systems designated as protected, and already there is an elevated schedule of punishment and fines. I think it's 25 years or up to $50 million or something like that. The challenge we face in putting recklessly throughout the legislation, and in particular in this instance, is that it would essentially preclude the ability to do it against the systems this very act designates as protected systems. And so just to say that within the context of your job and you're not working in a protected system, your act is reckless, is not sufficient to really, based on the body of knowledge, based on the profession, and based on certainly the legislations we have examined. And I know the point made about us being Jamaican, and this is really something that we bore in mind throughout our consideration of the point that was made here. The fact that there is an act that is committed against something that your personal knowledge should tell you that you ought not to do. In cybersecurity throughout the world at this point, the only time the act is said to be reckless is when those acts are committed against systems that are designated as protected systems.
Chairman, I would also add that to the point that the member made about this is Jamaica, that there is and has been a move generally across the globe for harmonization of legislation around cyber crime or computer misuse. And the reason for this is that cyber crimes don't generally happen in isolation. Yes, there are some that are located in the jurisdiction, but there is the trans-border nature of cyber crimes. And one of the things that certainly when they're being prosecuted and law enforcement has to approach another country in respect of these matters, particularly if we come to issues of extradition and mutual legal assistance. If there isn't dual criminality, then we run into problems we will run into problems. The fact is that to the extent that the offense is not similar to an offense in another country may either prevent us as Jamaica or another country from engaging different jurisdictions in respect of extradition matters, for example. And so while it is that a country can be different in its framing of the offense. We are guided by how the globe operates generally, or how countries internationally are operating. And what we have seen is that most, if not all, except for the exceptions, in respect of this particular offense, countries have been guided by what the Cybercrime Convention has as the standard, and that is that this offense should be committed when it is intentional, not when it is reckless or negligent. And so I want to put that into context, that we have to be careful, and that's our approach generally as we make recommendations to the committee, that we have to be mindful that while we are an independent sovereign state and we can do what we want to do in respect of criminalizing actions, we have to understand how that would play out in the national, regionally and internationally, in the context of a subject area that is not necessarily always local, but has a transborder element to it.
One last point on it, Ms. Murray, because I know I've been belaboring this point because I really feel passionately about it. But how would you treat with, as written now, how would our law treat with a situation where the person is aware of the risk, but shows disregard or indifference to this risk? Because I note in the Australian Cyber Act, the 2001 version, I haven't gotten a chance to look to see if there's a more updated version of their law. It actually criminalizes recklessness, if my reading of it is correct, because you have to somehow mitigate risk that comes from a disregard or indifference to potential harm. Is there something in our law which speaks to that, which would prevent that from happening? Because if not, then we have to look at the issue of recklessness as a real factor.
So remember, we also looked at the Australian legislation, and from my recollection, I don't recall Australia introducing recklessness in the context of this particular offense, which is unlawful access.
Division 477.21C of the
Right.
Cybercrime Act is what's
right. So I know I'm looking at it too, member, and that's where they have introduced recklessness is in respect of the provision on unauthorized modification. It's not a similar, which is different from what we're looking at here, which is unauthorized access.
Which is fine, but what if this access is, the more substantive point I'm making is where in that law, even though it's not the same thing, I am aware it's not the same thing, but what about if it is reckless due to indifference or disregard? Do we have something to counter that? That was my more substantive point. Do we have something?
So what we're saying is that this is access. This is just my entering a space. Where it gets serious, because I could access, and that's all I do. I just access. There's nothing that I do. So you are you access the system, but you do nothing else. You probably just loiter there, you look at a few things, but there's nothing that is done. What becomes where the consideration, and this is where I
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
Crime is Jamaica's #1 threat. As we stay apart while working together to fight COVID-19, we must all live good and unite against crime and violence in Jamaica. Live good means talk it out, don't fight it out. We must live good to build a safe Jamaica. Stay home, stay safe, live good.
Reduce your risk of viral illnesses like the flu and coronavirus. Wash your hands frequently with soap and water. Cover your nose and mouth when coughing with a tissue and dispose of it. Avoid close contact with anyone with the cold or flu-like symptoms. If you think you've been exposed to COVID-19, stay home. Self-isolate immediately and call 888-1-LOVE. That's 888-663-5683. A message from the Ministry of Health and Wellness.
Legislation captures what they've done. They've knowingly accessed, or they
know. But what I'm saying is, maybe I didn't phrase it right. It is that it's a risk, but they don't know what the risk is. They didn't know that X could happen. In their minds, there's a possibility that something could happen, but they don't know X, Y, Z, P, Q. So they have shown indifference and disregard. So they're being reckless because they can say they didn't know that X, Y, Z, or P or Q could happen. So I just want to know, do we have anything to counter that?
No, we don't have, as it is now and as it is framed, a person who, what the legislation speaks to is a person who knowingly obtains access, not recklessly obtains access. So what we're having a conversation around is whether or not recklessness should be introduced so that the person who recklessly obtains for himself or another unauthorized access would now commit an offense. Or if maybe framed a little differently, a person who knowingly or recklessly obtains for himself or another person any unauthorized access would commit an offense. Minister, and I see the time. I just want to put this back into context as well. I mean, we are. The conversation earlier was around legitimizing the actions of white hackers who would knowingly going to access a program or a computer and be allowed to do what they want to do, essentially, although maybe to the benefit of the resource owner. But here, the consideration, what we'll be saying is that, okay, you can't recklessly enter. So, yeah, I'll just leave that there.
I don't see a conflict in the two, but I just want the records to reflect. I do not support, you're not supporting the recommendation. I'm still not convinced. Public health implications of the pilot of garbage in communities across Jamaica. Ms. Daly says that she continues to.
All right, members, I think we're gonna have to check this up on the next meeting. There's overtime now, and there's another meeting coming up. So we'll have to stop here today, and we can start and take up from where we left off. The meeting is being proposed for Thursday, the 17th of February, 2022 at 2 p.m., not 10 p.m., not 10 a.m., 2 p.m. And there's another one that I'll be chairing at 10.
Chair, the Joint Select Committee for the Tobacco Review is at that time at 2 p.m.
Excuse me, no, it's not.
That's
member,
the
but
last notice I got.
we'll advise.
I have it as that.
Senator,
Maybe it was proposed.
You're right.
So what is the status, Ms. Mack? It is 2 o'clock. Is it time that we proposed?
It would be the Cybercrimes at that time, sir.
Okay. Thursday, February 17th at 2 p.m.
Yes, sir.
All right. So CTD will take off from there with Ms. Rodriguez at that time and continue with the deliberations at that point.
So tobacco just got smoked.
Tobacco is
Evidently
off the table. Tobacco will have to be inhaled another time. All right. So I think it was interesting. Thank you, CTV, and of course all the members for their inputs. And we look forward to continuing on the 17th at 2 p.m.
Welcome, Minister. You're welcome, members.
All right. Until such time, stay safe, members, and thanks for the supporting staff. And we see you at 17th at 2 p.m. All the best.
All right, Chair. Okay, everyone. Stay safe.
Stay safe and healthy, everyone.
thank you. Have a good rest of the day.
We work to make communities safer by essentially looking at the structures in the community that contribute greatest to social capital building.